Good afternoon, everyone. Thanks for joining. We're just going to give it a minute to make sure we get everyone sort of admitted here. All right, I think we can kick it off. Thanks so much for joining. As we sort of let folks in here, we have a few things to review, but as opposed to different peer networking events, we're going to sort of really open it up more for discussion today. So we'll actually hold off on our presentation materials for a little bit later, but we'll open up the floor for sort of comments on competitions and questions and additions to the agenda or anything. So I'm going to hand it over to Gabe so he can just give us a brief introduction here, and then we'll go ahead.
Thanks, Patrick. I'm Gabe Gilman. I'm the board's general counsel. Thank you for being with us today. I think what we'll do is I'll talk for about 5 minutes about how we see this peer networking event unfolding. Maybe give 10 minutes for our audience members to kind of set the agenda themselves and maybe say if there are particular issues that you'd like to see addressed. I can tell you that our plan, or Patrick's plan in mind, for this talk really has two components. The first is to talk about how cannabis competitions can be done inside the regulated system and how we envision that working, because I think there's been a lot of interest in that. And then I want to back up for the second half of the presentation and just kind of talk about events and communication more generally, so that we can kind of set expectations about what the agency does, how it works, and how best to kind of communicate with us around regulatory uncertainty. And all of this, I think, is part of a bigger picture turning of our focus from the initial mission of standing up the what then new cannabis market and bringing people on board, to now trying to work with industry as the market matures, as people try to innovate and do new things in order to show consumers their products and in order to kind of create newer and better things within the industry. So with that, I'll stop talking and see if anybody in the audience wants to pose questions or put anything on the agenda or has any comments to start with. We can take cues from you as far as how the rest of the conversation unfolds.
And if anyone wants to speak at the outset, you can use the raise hand function and we'll try and call on folks that way. Sean.
Hey, good afternoon, everyone. I know this particular conversation is geared towards around competition specifically, but I feel like this is just a very small microcosm of our larger issue of what we're broadly defining as events in general. I essentially would just like to be able to go out in public and consume cannabis offered to me and purchased through the legal pathways, but be able to just sit down somewhere in public that is within the rest of the license or permit parameters and be able to cannabis. And there's not necessarily an event going on. It doesn't have to be a concert with a weed bar. It doesn't have to be a wedding. Like the whole event thing is cool and we do need that, but we're also just largely talking about public consumption in general. Other event types other than competitions, because all of these issues are going to start backing up into each other. Competition doesn't really mean anything unless we can actually taste or sample the products. So, all of these issues will begin backing up into each other. And what we have right now is the alcohol pathway of how we've seen public interaction, public consumption, public licensure, and we can apply all of those same methods and models to create safe public consumption in the context of these permits, events, and licenses. And just my very brief perusing of title sections, subchapter 4, talking about tasting and event permits. There's 251 through 259. I think 251 is the only one that speaks to actually having to have any form of inventory tracking. And because that license type talks about a public member alcohol from a licensed distributor. But seemingly reading through 252 through 259 about special event permits, tastings, and everything we're talking about today, there is no mention of any of these alcohol companies having to do a spot of inventory tracking. And yet we are being, as an industry, bent over the barrel to the compliance and to make sure that every microgram of THC is accounted for. The alcohol industry is not beholden to any of those same compliance, regulatory, or reporting matters. Or if they are, they're not clearly stated out here in the public forum. So I'd like to make that mentioned and put on record. This isn't a public meeting for record, but just as we're all generically talking conversationally, and the few people that are here representing the board that do have the ears of the legislature, maybe go back, have a conversation with those folks and let them know, like, hey, there is a big double standard and disparity between these two products and industry types. Thank you.
Yeah. Thanks, Sean. And I can say we're, part of today's talk, or the second half of today's talk, is really about how we as the board and staff and the regulated community can work better together and communicate better together within the constraints that the General Assembly has given us. And so, nobody's kidding himself about the difficulties posed by the blanket prohibition on public consumption. As an executive branch agency, we can't do anything about that in the here and now. That's got to be done in the General Assembly if it's to change. And so I do want to point out that we're going to kind of constrain today's conversation to discussion of how we can work with the imperfect laws and rules that we have now. But what you have pointed out, I think, does go to the point of the second half of the talk. There are going to be instances where perfect compliance may not be possible. And we're often, challenged to kind of give a lot of predictions where that isn't always possible. So we'll cover it in that sense, but in terms of the legislative priorities of industry, we probably won't go there as much. Tito?
Hi there. Can you hear me okay?
Yeah.
So, I appreciate this gathering to talk about it, but I kind of agree with Sean. Like, we're just so far from a cool scene or this being optimal that I don't even know where to start. It doesn't feel possible. It doesn't feel like competitions are possible right now with the rules on consumption, like Sean was talking about, but also the crippling advertising. I don't know how anybody's going to know. The fees that the CCB is dishing out right now are enough to put companies down. So everybody is scared shitless. It's just, it doesn't feel like we're there, unfortunately. But I appreciate the sentiment.
Yeah, I think we're, I think the message from here, from the bureaucracy, is sort of that this is a project that's going to proceed incrementally, and talking together at events like this one about how we can operate within the rules we have now is an important way to kind of put a good public face on our ability to do things in the future that may not have been authorized by the General Assembly yet. I think the board, I think, has broadly recognized that in the fullness of time, there'll be room to talk about catering style permitting and event permitting, and how can you have a managed public consumption. We've got what we've got now, so we mostly want to focus today on how do we enforce what we actually have. and how can you, communicate effectively with us when necessary, as well as what you can expect from a public agency. There's some things that just can't be done or have to be left to the letter of the law for people to decide for themselves. So I know that's a little bit cryptic, but I guess we could. I don't see any other hands, so we could launch into PowerPoint that talks about how we could do events or how we could do a competition under the existing rules. And you will encounter there the same frustrations that both speakers talked about. Without being able to have public consumption, it really is not easy. It certainly isn't exactly what one would hope for at a in a conventional competition, but it can be done. So great way for industry to showcase excellence among craft cultivators and product manufacturers. There's so much in this marketplace to be proud of, and evolution almost on a weekly basis of what's available to the consumer, and almost continuous quality improvement in what's available to the consumer. So we want people to be able to show their talent, show the talent that they've put into cultivation and manufacturing. The rule that does that, or that makes this possible, was added in October of 23 in the second iteration of the board's administrative rules. It's 2.3.9, and it was the first time that the rule allowed for competition samples. 2.3.9 is short, it's pretty easy to follow, and it calls for express written authorization by the board. And the board, so a licensee would want to approach the board with a written proposal to have a compliant competition, talking exactly about who would play what role, what establishment and what license ID card holder would sort of be in charge of quarterbacking the events, ensuring compliance, transportation, distribution to judges, selection of judges. One of the things the board would look for under 2.3.9C is whether the competition is sort of a real competition. I mean, there's a plan for meaningful objective evaluation by judges. And there, despite the advertising restrictions, there's a lot of room to, make this an exciting event that members of the public would know about and be interested in. In and of itself, a competition is not a promotion of the sale of cannabis of the type that is necessarily advertising. So in many ways, you wouldn't be pinned down quite the same as you would be if you were advertising your dispensary or your cultivation operation directly to consumers. The event is just that. It becomes, an advertisement as soon as it tends to promote sales of a particular thing or at a particular place. And so that would happen more once you have a winner, somebody who's got the medal and wants to put the medal up in public to attract consumers because they have been recognized for excellence, would then be advertising. But all the way up until then, you're really not that bound by advertising rules because the definition of advertising isn't yet triggered at the point of a competition or organizing a competition. So, that's one of the things that we can work out in the written authorization, to the extent there's uncertainty about where the lines are and who will be doing what. That authorization, which is going to look more like an approved plan than just a check, will help set expectations so that the organizers of the event would have some confidence and some certainty going forward. The basic ground rules that are written into the rule are 8 grams per strain of flower, no more than 7 strains, clear label competition sample not for resale, and entry in inventory tracking consistent with the mandate from the General Assembly that we have seed-to-sale tracking. As we talked about earlier, we've got a lot of constraints that are not necessarily friendly to a competition as you might first imagine it. The basic ground rules, though, can be worked out. Adult use licensees should be the only participants. One thing that we almost never can have is crossover between either home grow or illicitly grown cannabis and regulated cannabis. The two really have to stay in separate lanes, and the folks involved have to stay in separate lanes. There's also the question of who's being promoted and who's being celebrated. the regulated market, I think, needs to some extent protect itself from unfair competition that is not constrained by the regulations we all follow for the good of the public and confidence in the products. Products should be registered. The whole idea of a competition is that the things competing are available to consumers, and that once a product or a cannabis strain has been recognized, consumers can actually go and get it. So products should always be registered. The authorization will be written with clear terms on letterhead, so there'd be no confusion about what an authorization is. It would announce itself really clearly. It wouldn't be words spoken over the phone. Unlicensed folks can't collect or transport samples. You'd have to have an employee of one of the involved cannabis establishments acting within the course and scope of the employee's employment, who had a valid employee ID card or principal card. Consumption is a problem, and everybody's recognized it should occur on private property. If it's not your own property and you've got a gathering there, make sure there's a provision for safe travel home or stay over. That's one of those issues that we can't. There's nothing that we can do at the board to help you through, unfortunately. But people have found their own accommodations with this, and so private residence really is necessary to have a site where judges can work with the product. The personal use exemption, importantly, doesn't mean that cannabis establishments can violate laws and regulations 1 ounce at a time. It protects individuals from detrimental treatment, including prosecution for possession, but it doesn't excuse regulated entities from compliance with regulation based on amount. What it does, though, is that it allows that unlicensed judges can participate in this event. They have to be lawfully issued samples in appropriate quantities, but their possession then is protected. And so it is not the case that every last person would have to be an employee of a cannabis establishment in order to be participating in the competition as a judge. For this part, I think we want to back up a little bit and talk less about competitions and more about effective communication generally between the regulated community and the bureaucracy. We've always got a tension here, because this is an executive branch agency, between consistency, predictability, and the desire to give everyone a level playing field, and the desire also to allow room for creativity and innovation and change. And that's one of the reasons we're updating our administrative rules as frequently as we are. It's very unusual to see an administrative agency churning out new iterations of this rule every year. That's really a function of how new this market is and how new this entire program is. But we're trying to do that in order to achieve these goals and to balance those priorities. Because the board is an administrative agency, it really speaks in writing in terms of what there is to know as an operator within the regulated community is what's in the statute first, then what's in the administrative rule that's duly adopted, then what's in guidance published by the board, then what's in published policy, and then what's a voted act of the board that's recorded in minutes. The important thing about each one of those elements is that it's written and it can be found by everybody. It's not just available to somebody who's the recipient of a letter. Every member of the regulated community can see the ground rules and interpretations offered by the agency, almost all of it at our website. That's a really important way to make sure that we treat people fairly and equally and offer predictability to the people we serve. Similarly, the board acts by a quorum of the members present and voting in an open meeting. We've got 3 board members, of course, so that means 2 board members at an open meeting are really required to take any official action on behalf of the body. So another way of saying that everything that is official is written down, and everything that is written down is readily available from the website. Part of the accountability and transparency of a public body is that it acts through its public acts, the ones that you can read about on its website. We're trying to get away from, I think, what was an important element of the early market when there was a lot of one-on-one interaction and kind of coaching to work through the barriers to getting started up. But now that the program is maturing a little bit, we really can't and shouldn't rely on one-on-one communications or questions posed over the phone or something. They don't really have binding effect. They can undermine fairness and integrity and consistency, and they can lead to a lot of frustration, a lot of misunderstanding. It is possible in rare cases to obtain a waiver under Rule 2.16. The rule gives the standard that is applied when somebody seeks one, and that is that the waiver has to be necessary to achieve the purpose of Vermont law and creates no danger to public health, safety, and welfare. That's a pretty high bar, meaning those are not readily given out because it's rarely necessary, although it may be desirable to waive off one or another rule. Waivers are also discouraged by the State's Administrative Procedure Act, which, for many of the same reasons we're talking about, says that an agency really shouldn't routinely be waiving a rule without amending it. If you're doing that, it means you need a new rule, not that you need to let more people through the existing rule. And again, that's just a principle that keeps agencies honest and that keeps the acts of a public agency transparent to everybody, so that everybody's treated equally and fairly. So we can skip up to. And then, repeating some of the things that we've learned or that we're trying to impress upon regulatees as we move forward into this kind of new phase and the market matures is that oral understandings, expressions of approval or interest, or silence about a plan really don't have significance except to the extent they generate something formal and written of the kind we were talking about. And that's it's really important to understand that because that the bureaucracy essentially is a bureaucracy. And in order for each part to know what the other part is doing, you want official actions. You don't really want, casual statements. Your compliance agent as well, it just isn't somebody who will be in the role of saying, can set priorities, but all they can really tell you about the existing law and rules, where to find it. It ultimately is sort of the responsibility of each licensee to discern the laws and rules for themselves. We try to help you with published guidance where there's a lot of ambiguity, advertising, packaging, for example. You can get tons of guidance that really aims at answering almost every question that somebody might have. And we have refined that, but we also want to leave it alone at some point. Some stability and predictability is really important to everybody. And there's another kind of funny thing that comes out of that, early interaction where it was very heavily one-on-one. There's sort of a desire to have predictability all the time about what is going to get enforced aggressively and what isn't. And it really isn't something that a public agency can or should do in order to have an effective deterrent that encourages everybody to comply voluntarily. It's actually helpful to have a little bit of uncertainty about what violating a law or rule might mean. An example of this is if I call the state police and I say, I'm going to drive 72 miles an hour to Burlington from Montpelier. I'm going to do it at 10 a.m. tomorrow. What do you propose to do about it? Can you tell me whether you'll stop me? Will I get a ticket or won't I? At some point, they're going to hang up on me because they can't, it doesn't serve anyone for them to do that. And a similar thing goes on with regulatory compliance. The way to avoid risk of enforcement is to be in total compliance. If something happens that may not square with the rule or that is sort of falls into a gray area, one has to decide for himself what's the risk tolerance there. But it's pretty easy to understand how the board prioritizes. It prioritizes with its duties to the public health, safety, and welfare first, followed by concerns about making sure that we have a market that has integrity and that's fair to other people, and fair among competitors as well as protective of the consumer. Rule 4.7, which is part of the disciplinary rule, gives a list of factors that we're told we have to consider when there's been a violation. It's a great place to look in terms of what are the things that are being assessed when the enforcement unit decides what its priorities are. And ultimately, our goal is to develop a culture of compliance where regulatees and the board have a shared understanding of the rules, have high expectations of one another, and where everybody in the licensed community becomes, kind of shares norms about how things operate, and in that way feels that they're treated fairly and sort of playing by the same set of rules. And again, I understand that, really do, the frustration with what can seem like a very slow pace of kind of legislative evolution as the solidifies and people are looking for new ways to innovate. We're trying there, and but it does require cooperation of the entire General Assembly and coalitions of people who are comfortable taking those forward steps. So that's why we sometimes have to enforce laws and rules that we maybe don't wish were there or that could be cast a little bit differently. So we ask for your help with that, and I hope that explains sort of what you will and won't hear out of the agency as you're going to plan things and as you're trying to work with uncertainty. That said, we've left open almost a half an hour if we need it for more open discussion about any issues that you're seeing, anything I didn't address, concerns you have, or suggestions for how we could do better if you in terms of serving you.
Once again, you can use the raise hand function to get yourself in the queue if you want to have a question or comment or anything. Sean, go ahead.
I know this has been competition based, but if we've got a little bit of time, maybe again, these other kind of other license types or event types, can you maybe speak to the development or current sticking points of any of those, presuming that everything else is in place? It was a private location or private venue, so the consumption matter has been taken out of it. Would we see any other license type issuing this year or permitting of any specific, what we're calling quote unquote events, or are there still things that need to be worked out?
We're coming right down the pike to the end of the legislation. It looks at this point a farmer's market mediated by a retailer with fairly open participation from other market participants overseen by the board might get the go-ahead for a pilot project, which would involve sort of this summer and fall 5 demonstration projects. We're waiting a little bit to see what lawmakers come up with there, but that's sort of a first step. It doesn't include or isn't planned to include public consumption at this point. You've probably seen the challenges that come along when we try to build a coalition to create new licenses or opportunities to have events that involve cannabis. And they're probably pretty familiar to you. I think the prevention community wants to make sure that there won't be increased access to children or overuse. A lot of concern about highway safety as well. If people are congregating in places where they drove, desire to make sure they're unimpaired when they get back on the highway. So those are pretty familiar to you. I probably am not telling you anything you don't already know. But as you can imagine, the challenge is to show people piece by piece that these things can be done safely, that they can be done responsibly. And then once you've done that, it becomes easier to build a coalition for sort of a next step as the market matures. And in that way, we'll get to a place where I think you'll be able to offer more things to your customers.
I certainly understand all that, and maybe I am what all of us in the community maybe feel like, and I use you all loosely, certainly not you individually, the board, but just what we'll call bureaucracy. Maybe what bureaucracy doesn't understand is that all of these things that you hear us browbeating for at the start of the meetings are all of just the things that we have had culturally that we've just had to hide, but we've had all of it. We've had, access to cool products that people have been developing. Yes. And I'm talking about in the legacy market because we're talking about culture and society. And maybe when you hear some of us get super sad and be like, wow, this just doesn't sound amazing, is that we've had all of this and we've had to fight and hide from legal enforcement throughout all of those years of having it, but we had it. And now that everything's on paperwork, all of the cool stuff that we've had is now gone, seemingly. And so I just, being able to put that out there rhetorically, because I see that the call here is monitored for the quality porpoise, that whoever in bureaucracy might go and check this out has some understanding of like why this has felt like pulling teeth for 4 years when we've just had this stuff generically for the last 20, and we are all good people that are wanting to pay taxes and not harm children. And the whole thing about the public prevention groups is they shot themselves in the foot in the first place when they approved cartridges so that people can walk around high, hitting cartridges anywhere in public discreetly all day. But I can't sit at home with a blowtorch and a quartz rig, which is not public friendly, and buy concentrates legally above 60%. So, like the whole public health prevention thing, I get it. I've been an event manager for the last 15 years before I moved into the cannabis industry. I've been responsible for public safety, making sure that the requisite number of porta potties are there per number of public 2-year event license. I've had to be the person on stage to kill the party and send all of the patrons back to their car because we have a weather cell that's moved through the area. So believe me, I understand that. I'm very conscious of all those things, and when I ask like about what you guys can do to go back and talk to our legislators, when I ask the questions rhetorically or ask them here in the meeting to you, it's asking rhetorically because I know I'm not going to get the answer, but it's more so just to stimulate the conversation between the border bureaucracy and the legislature, because you guys have their ear much more directly about these things. Hey, we've over and over. How can you guys fast track it?
Yeah, we hear you, and I think those arguments are come up every session. Ultimately, it's beyond the power, and I appreciate your understanding of that. That it's beyond the power of an executive branch agency to do anything more than try to help people make those coalitions to get agreement to move things forward. And I think the board has done that, and we're grateful for everybody's patience as they've tried. It really is kind of a very incremental and sometimes frustrating process. But it's one where if we put the best possible face on the market we have, it's easier to bring people along. Bernie?
Hello, can you guys hear me?
Yes.
Thank you for putting on this event. I just want to start by saying that I would like to continue with Sean's argument and just, like he said, browbeat this till the end because we're trying to push forward events with, a situation with this public consumption and even just possession. But I do have some ideas about maybe doing events. I just have issues like the event permit where there would be 5. I just feel like narrowing it down so to such a small scale like makes it rampant for corruption potentially. Um, However, a lot of states operate competitions with judges' kits.
Mhm.
And so knowing the ins and outs of product registration as a manufacturer now, I think there's possibility of registered products being available for competition distributed through the dispensaries. The dispensaries would create a new registered product that encompassed all of the samples. There would be deadlines for applications and all these things. The consumer would purchase the judge's kit, and that would make them a judge, which would give them access to an online portal to make voting. I'm not really sure if the CCB is the body that would manage this. Um, you know, it's possible. You know, something else to consider is the purchase limit for a consumer. So every judge's kit would be limited in that sense too, which would limit how people could join, how many people could participate. I'm not for limits. I think this is a problem. Um, but given all this, the CCB's flexibility on waivers, there could potentially be an option for for something that's done not publicly, but you know, kind of like 7 days. That's it. And if you guys want to talk to me, um, you can reach out. But I do have some ideas, and I've witnessed some other events in other states. So cannabis specific, they didn't have to go through any kind of permitting for what they were doing at all. So that is complicated, but given that there is no public consumption and we don't even have an event permit yet, and when we do, we'll only have 5. And I think the CCB would be kind of overwhelmed in making one of those 5 events a competition, but maybe it could be the 5th. There are some ways though. Thank you.
Yeah, thank you. I think you're kind of already thinking of the things that we would need to work through if to get one of those permits under 239. But that's exactly the kind of thinking that I think we'll make the first one of these possible under that rule. Just sort of drafting out how it would work, recognizing the boundaries that we all have to work with, and finding ways to get judges in place and product to judges. It can be done, but it can be a challenge. But you're thinking all the right things, Rev.
Hey, can you hear me?
Yeah. Yep.
Great. Thank you for doing this session today and for considering this issue and working with us. I wonder, I think this falls a little outside the exact purview of what you're working on for a competition, but we talked about it a little bit in relation to the Vermont Cannabis Convention in terms of displaying products. So I think about some of these competitions often will have like an awards ceremony or an awards party and some sort of public component. So I just wanted to put it on the board's radar if there's a way forward for that sort of thing of like having a display of the winners in a public setting where the growers, the winners can show off their products and their awards. But that kind of ties into the kit invention idea a little bit too. But just wanted to throw that out there.
Gotcha. Thank you. That's a good example of sort of the challenges we get into if we're asked, I plan to do this thing. I must have an answer. Can it be done or not? All we can really tell you as an enforcement agency is, there's a regulation against cannabis establishment transporting cannabis other than to another cannabis establishment. So it's helpful to have that kind of thing going on the site of a cannabis establishment, because then you're not confronting that rule. So we can't always answer every question about everything somebody might want to do. We can really just kind of steer folks into the direction of, what's the most compliant approach that you might be able to take. Displaying cannabis under the existing laws and rules is a mess because of the prohibition on transport outside of the system or to sites outside of the system. So staying inside regulated cannabis establishments is definitely the easier way to go, but that's another area where we've kind of got what we've got, even though it makes it challenging to celebrate the winners and outside of the regulated establishment. Sean?
So would it sound like just having to work out the legalese that if a promoter of an event has chosen a venue and has gone through all of the permitting process, generically of being an event, whatever local jurisdictional authorities they're beholden to even have public assembly there, regardless of the reason, they've gone through all that, that's all good. Then we attach on the cannabis things and your guys' entire checklist at that point, and you guys have signed off a permit to say this promoter at this address is good to hold a cannabis event. Do we grant them temporary quote unquote licensure, day licensure? And so at that point, the transport issue has been taken care of it. And that's literally just legalese. To me, it's all smoke and mirrors, but if it's literally the legalese that we have to go through, does somebody in the board have to go, I make a motion to grant temporary licensure to those who have gone through full permitting process to hold a cannabis event? That's just a proposal for me.
It's an interesting question. It brings me back to something I omitted about, the limits of the board's authority. The board can waive its own rules when that relatively high standard of necessity is met, but it has no authority to waive statutes passed by the General Assembly at all, or to waive the rules, regulations, ordinances, et cetera, of a third party body like, the town ordinances, the fire safety rules or something. Those belong to other people. So for all those reasons, anything involving a competition is much easier and almost necessary to be done at a cannabis establishment rather than offsite, because under Section 901 of Title VII, every license permits operation only at the licensed site. The board doesn't really have authority to say, we bless, this event at this park on a particular day. It can't really do that. So all it can do is work with an organizer who has made an application under Rule 239C to say, how's this going to work? And that's a good opportunity for flags to go up if, for example, there was a plan to be in a third party space that wouldn't work. It's an opportunity for everybody to say, okay, that won't work, but how do we move it into something that will work before the event goes off, and then to be confident that that everybody involved can have fun and do what they aim to without having to worry.
Yeah. So, but it also sounds like, I guess we need to kind of get, and again, this is all literally just what somebody else in our community made a very thoughtful, amazing presentation of a couple months ago, of literally stripping the entire state of Vermont's website and any mention of alcohol and event, just basically cloned their entire template of how to do this. And it sounds like we just kind of need to do that for cannabis. And so it sounds like before we're doing real, what I want of open public catered events, it sounds like we maybe need to kick off the catering license component. Because imagine like how many caterers are servicing weddings. Those caterers are having to go back to a licensed liquor distributor, and they're now taking alcohol from a licensed alcohol storage facility to a temporary day permitted facility that they're serving at, that is not a full-time alcohol licensed establishment. And so all of these changes that need to happen at statute level, I know we're literally getting ready to enact everything that we've gone through this past winter and spring. All of these issues that are at play right now, are these kind of off the table until next spring again? Or are there statute changes that we can initiate within the next 4 to 6 months? Or are we kind of stuck until next spring on all of this and just have to do it as one big go round each year?
A lot of that is up to the General Assembly. You're at the very end of the legislative session. And so for practical purposes, yeah, I mean, the vehicle that you've got now is that is really on track to look at the 5-event pilot program, trying to make that as successful as possible, to involve as many interested people as possible, and to have those events go off really seamlessly. And then that would put everybody in a position to be talking next year about what we learned from those events. I think part of the legislation that would make them possible proposes to require the board to file a report with the General Assembly. It tells them basically, what do we learn? What went right? What went wrong? How do we take the next step here, and maybe what would we not do again if we had the chance? So it's a lot of experimentation. It happens slowly and bureaucratically, but you're right in terms of, in this process, I think it's very frustrating to go for broke because you'll often kind of wind up broke, kind of have to choose, goal, have a plan. And I hear some really smart plans already where people are talking about how can we do this? How can we show it's going to work right? Do that thinking in the downtime. And then I think try to build a coalition around how can you safely and responsibly achieve some of these goals, and have them kind of prefab going into the next legislative session when the legislature reconvenes. That's much easier than trying to kind of last minute everything in the middle of a process.
I was asking more so, like, I know we're at the last part. Everything we've been doing over winter and spring is now closing the next few weeks. But are there any other legislative or legal type actions that we as the public could take to reach out to our legislators and have them sometime in the fall be like, oh yeah, let's just shift this one thing? Does everybody agree we're going to take a vote on just shifting this one little thing so these guys can have like a harvest party this year? Or are we just, is that entirely off the table from how the legal and political mechanisms work, that they're not able to make a minor shift? We're just stuck to like what's happening the next couple weeks, and then we got our next shot for next year, is kind of what I'm asking.
Yeah, it's more the calendar than anything legal, strictly speaking. Our legislature, of course, is not a 365-day a year legislature. So the fall is kind of quiet time in Montpelier. Nobody's really around. So it is fair to think that, the fall is when industry and the board's always around, industry players are always around. We can think about how do you build consensus? What's the model look like? At NECAN, I think we saw some really interesting stuff where there was many people probably saw a demonstration set up of how could you put all the security apparatus basically on one pole with cellular connectivity, have a secure tent and that kind of thing. That's exactly the kind of thinking that can go on in the downtime, and lead to really well developed, mature plans when the legislature is operating. It takes sometimes months to think through all the consequences of various changes, including things like the tax consequences or the highway safety consequences, and that somebody's going to ask about all of those, and so you really want to have thought them through. So it's there are different points in the calendar when it's helpful to do this or that, and we are coming to the close of the period where the General Assembly would be changing the laws and moving more into a kind of planning period that I think you could think of the fall representing.
Sure. Maybe have some of the board reach out to some of us in the entertainment community at some point. There's a lot of valuable overlap. I retired. I managed to retire a few of my coworkers out, and their working interview at some of the first dispensaries that opened in the state were basically walking in with a stack of fake IDs about 2 inches thick, and a dispensary owner going, this is what you do? And they're like, yeah, all day, every day. And my friends were a lot happier just checking IDs at a dispensary door for happy stoners than having to deal with angry drunks at 2 a.m. So reach out to us as an industry. There's a lot of good people that can put in some good input to help make these changes happen conversationally.
Yeah, that sounds great. And I know, our 3 board members spend their time monitoring what's going on in other states as well. Conversations with you and what you know about what's going on in industry in other states is really helpful. And the more we know about lessons learned elsewhere, as you know, this is a state of 660,000 people. There's so many other laboratories running these experiments that there's a lot of opportunity to look around the United States at what's gone right, what's gone wrong, what we might want to copy. It's not always necessary to reinvent the wheel in Vermont. And sometimes if we can find a successful model elsewhere, duplicating it is often a popular way to build consensus, because people can look at it and where it was going well and say, okay, we're ready for that step. Robert.
Robert, I see you're unmuted. We can't hear you at the moment. While Robert's figuring out the Microsoft Teams, does anyone else want to go? Stephanie, why don't you go ahead?
Hi, everyone. Can you hear me?
Yes.
Hi, Stephanie Waterman here. I'm a licensee. I have a dispensary. I'm a grower. I've been running a grow store serving the Vermont industry for over 11 years. I want to point out, we've successfully held, I don't know, 4 cannabis competitions in the state since legalization, prior to adult use, when we were under the home grow laws. And I really hope that you guys will continue engaging those of us who have been sort of involved with these events for many years, sort of putting them on successfully under our own regulations and under our own responsibility. Because I think if we work together, what you're trying to do here, which I acknowledge, and I thank you for that. I think we can figure this out. It seems to me, I want to echo what the other speakers have said, that we need to solve the events permit issue. We need to solve the off-site display issue. It's absolutely insane that a grower cannot show their cannabis at an event. They should be allowed to do that. It's still in their possession. The other thing that is within the board rule, the 8 grams per strain and, 7 strains max for a competition. 8 grams is just not enough to effectively judge, to have enough judges. The 8 grams of 7 strains is 56 grams. If you would consider changing it to 2 strains max at 28 grams a piece, you'll have a more effective sample size that we can judge. You need to have a certain number of judges to make the event worthy. And I think that's an easy board rule that could be easily changed. So thank you. That's all.
Okay, thank you.
We may have lost Robert. I don't see him anymore. Are there any other comments or questions?
It sounds like maybe a wrap, and we're coming up on closing time anyway. So if you think we're good, thank you everybody for dropping. Oh, Bernie, I see you get your hand up.
So I must have missed that 7-gram thing, but I don't think there should be a limit on the availability of samples if they're being purchased or if that's the route you're taking for now. You can't limit anything. Stop limiting things. We need like a large sample size. Like for something like this. So anyone should be able to purchase a judge's pack of flour for whoever's in the running or whatever it is. And those should just be made available to the point where there's 300 out there, because they will sell. I just wanted to get that in there. Thank you.
Yeah. Guys. Thank you, Bernie. And we're a regulatory body. We got to limit things. We can't. What can we do? But I take your point. I think if you look at the rule, it really contemplated samples that are given by organizers to judges. Over-the-counter sale to people who will then rank things, I think, is a different thing. The important thing isn't that we solve all these problems right here and now. It's really just that we plan for, how can somebody who wants to do this effectively approach the board with a plan under 239 and work out kinks just like the one you were talking about, Bernie. Because it may be exactly that. Okay, the samples aren't going to do it to get enough judges for this to be representative, but we can do over-the-counter sales to overcome that. That's just speaking off the cuff there. That's the kind of problem we can solve through this kind of permitting process. And then, of course, we appreciate your understanding of the hard limits on us. For example, if you're to say, we want to do consumption in a public area, as an administrative agency, we can't help you with that. It's never something that would work, but we can work with you to find things that will. So thank you.
I'm aware. Yeah. I just
even
with this and event permitting and everything, I just want the board to be aware of the bureaucracy that let's not rush things if it's not the right thing, right? So just keep that in mind. That's how we got S54 and how we are where we are today. So that's it. Thank you for having this event, though, and Zach or Sean LaRock, thank you. You had some great insight. Appreciate that.
Thanks to everyone who chimed in and participated. We really appreciate having these sorts of listening sessions, really. And thanks for listening to us as we kind of went through our part. Any last words? Otherwise, we're just coming up to the end of the hour, so it's probably a good point to call it. All right. Sounds good. Thanks, everyone.
Thanks, everybody.